Hi everyone, welcome to Beyond the Evidence. This is the channel where justice matters. My name is Marv. I am a true crime fanatic, and I love to dig deeper into the mysteries of unsolved cases. Join me as we search for missing persons, uncover the clues in unsolved murders, follow along with jury trials, and we'll be a voice for the voiceless. I'll share with you the facts, the theories, the clues, the evidence, and the controversies that surround these cases. This is Beyond the Evidence. Good evening, everyone. It's a chilly evening. We had the air conditioning on too long today, so I have my bathrobe on to keep me warm. You were watching a movie and heard a female voice. Well, welcome, Lollipop, and everybody else who's watching. Thank you for joining us, and thank you to those who may watch the replay. We're going to go over court documents that have come out. So we are going to get started because there are a lot of them. Let's see here. Oh my goodness, there's so many of them. All right. I think I've got my screen up here. We're going to start with this was filed September 23rd of this year, and it's motion for jury to view scene. Richard Allen, by counsel, pursuant to IC 3537-2-5, asked the court to order that the impaneled jury be transported to the Freedom Bridge, the Monon High Bridge, and to the site where the bodies of the victims were located, as well as the site of the old CPS building where the prosecution claims Richard Allen's vehicle was parked between 1:30 p.m. and 4 p.m. on February 13, 2017. The view would be requested as it would greatly aid a jury's understanding of evidence presented at trial, including observing and feeling the unique topography of the land, something that cannot be understood from photographs and video. Specifically, the request is for the jurors to walk the trail from the Freedom Bridge to the Monon High Bridge, to then view the opposite end of the bridge where the victims were allegedly abducted, finally to view the area where the victims were found, and then the location where the prosecution claims Richard Allen, there we go, Richard Allen parked his car from 1:30 p.m. to 4 p.m. on February 13, 2017. These locations are less than 2 miles from the courthouse. Juror transport and viewing could easily be completed in under 90 minutes. Allen and his counsel, Andrew J. Baldwin, Bradley Rossi, and Jennifer Ajou, request to be present along with the prosecution and observe the viewing under whatever direction and guidelines the court may order under Indiana Code, gives that code again, because of any security concerns. The court does not wish to allow Allen to be transported to view the scene. He waives any such right and asks that the court order this jury view occur without him. So, what is the big deal about taking the jury to the scene. Well, if you ask me, it's a little bit dangerous. Don't think they learn much there. Yeah. Well, the issue is not the CPS building, and it's definitely not the trail between the Freedom Bridge and the Monon High Bridge. And actually, the north side of the bridge, because that bridge has been updated. We know that. It's got railings now. So that's not an issue. The issue is the south side of the bridge, because unless they're going to get approval from the people who own that land to bring them, take them and travel them around by road, and then use those property owners' land to bring them to the south side of the bridge, they can't walk across the bridge to get there. So, that's one issue I see. And then the other issue is the steep terrain getting from the north side of the bridge to the actual crime scene. It's hard for us to get up and down those hills and ravines. So I don't know how a jury's going to do it. So we'll have to wait and see. So the next document I'm going to share with you is the order that the judge made with that. And basically, Judge Gull just said the court takes defendant's motion for jury to view scene under advisement, pending a response by the state of Indiana and a hearing to be conducted at the conclusion of jury selection in Allen County. So that tells me that she's going to hold a hearing after jury selection on the 16th regarding this. You can kick Criminal Network. You can ban him. All right. Then we received the motion to compel defendants or despondents to answer certified questions. No, the truth doesn't hurt. You're just an idiot. So, 1 second. While I take care of this. Okay. That individual has been removed. All right. So, motion to compel. Let me get this one up here. All right. So this was filed 9/23/2024. And it says, comes now the accused Richard Allen, by and through counsel, Andrew Baldwin, respectfully requests this court to compel certain deponents to answer certified questions in support of this motion. Defendant asserts the following. Over the course of time, several depositions have resulted in the defense certifying certain questions when the prosecution advised the deponent to not answer certain questions. The defense is requesting this court to order the deponents to answer the certified questions. The certified questions the defense seeks this court to compel the state's witness to answer are contained in the following paragraphs. On August 10, 2023, the defense deposed Jerry Holman, and the following question was certified. What did you talk to Sheriff Liggett about to prepare for your deposition? On May 3rd, 2024, the defense deposed Jerry Holman, and the following questions were certified. Why did it take you guys so long to get a blood splatter expert in April of 2024? B, why did it take so long for the investigators to get a blood splatter expert? C, did anyone in your unified command or greater law enforcement investigative team ever suggest that you should do that, retain someone to discuss blood splatter during the investigation? Okay. Next one. On March 22nd, 2024, the defense deposed John Gallipo. He's the warden of Westville. And the following questions were certified. I'm assuming some of that, talking to the prosecutor, was just talking about the pleadings I had filed or Andy filed, things like that? Question mark. B, and so what were you asked to do when you got the document, affidavit signed by John Gallipo? C, did they give you any reason why the defense could not go see where Richard Allen was living? D, do you know why they made the decision for no phone policy in Westville Correctional Facility? I don't see anything wrong with these questions. To me, these are common questions that a defense would ask witnesses. So on April 18th, 2024, the defense deposed Joshua Robinson, and the following questions were certified. Generally describe to me what kind of questions these were. Questions for the affidavit prepared by Elsie Gallagher. B, I'm not asking you about what Miss Gallagher talked to you about. I'm asking you what questions you answered for the affidavit. C, what were those questions for the affidavit? Number 8, on May 3rd, 2024, the defense deposed Tony Liggett, and the following question was certified. What was the purpose of that unified command meeting? I don't see anything wrong with these questions, but the prosecution may see something else. Number 9, on September 13, 2024, the defense deposed Stephen Mullen. Mr. Mullen refused to answer questions posed in subsection A through D below. Rather than answer the simple yes or no question, Mullen repeatedly made conclusory statements to defense counsel that Richard Allen was the man that Betsy Blair observed and was the man Sarah Carbraugh observed, etc. The deposition has not yet been transcribed, so the defense cannot be certain to the exact questions formed at the deposition, but the questions certified were to the effect of A through D below, or if answered, would have led to questions similar to A through D below. Let's take a look at these questions. A, is your timeline and theory of the case fatal to the prosecution's case against Richard Allen if the person Betsy Blair observed on the bridge is not Richard Allen? B, is your timeline and theory of the case fatal to the prosecution's case against Richard Allen if the vehicle Betsy Blair observed at the CPS building was not Richard Allen's vehicle? C, if Betsy Blair observed one person and Sarah Carbraugh observed an entirely different person, is the prosecution's timeline and theory of the case as it relates to Richard Allen fatally flawed? D, If neither Betsy Blair nor Sarah Carball observed Richard Allen on February 13th, 2017, is the state's timeline and theory of the case as it relates to Richard Allen fatally flawed. Wherefore, the accused respectfully requests that this motion be granted and that the court order the deponents to answer the questions that have been certified. Now, I don't see anything wrong with the first set of questions, all the way up until this A through D. I normally would not see anything wrong with A through D either, except for the fact that we have the motion to limine that states that they cannot talk about these additional people or Odinism. So I don't know how this would affect that. So we're going to have to wait and see. All right, the next set is the objection. Now, this is from the prosecution, and it is the objection, state's objection to defendant's motion for jury to view scene. Okay, now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland, and respectfully objects to the court ordering the jury to be transported to the Freedom Bridge, the Monon High Bridge, to the site where the bodies of the victims were located, and to the site of the old CPS building to view those areas. The state would, as the court, it should say, the state would ask the court to consider the following: that the defense filed a motion to have the jury view the scene on September 23rd, 2024. That the state objects to the jury going out to view those areas requested by the defense for the following reasons. The terrain where the bodies were found is very difficult to traverse and would be dangerous for the jury to get to. The traveling to where the bodies were found and the opposite end of the Monon High Bridge would involve encroaching on two private landowners' property. That it will require a substantial amount of time and resources to take the jury to those areas while ensuring that they are sequestered from the public and outside influences. That the areas of where the bodies were found, along with the site of the old CPS buildings, are substantially different from the time the crime scene occurred. 3, that the state intends to introduce into evidence demonstrative exhibits, maps of the various areas, and drone footage of the various areas to show the jurors the various places outlined in the defense's request. That any benefits of the jury visiting these areas is outweighed by the dangers such as a trip presents to the jury and to the fairness of trial. 5, that the state does not believe it is proper to have the jury view the scene or the other various areas. Wherefore, now comes the state of Indiana by prosecuting attorney Nicholas C. McClelland, and files their objection to the defense's motion for jury to view scene and would ask the court to deny the same. So, let's see. Electric, where cat? Yeah, I don't see a problem with those questions either. Yep. Why didn't he just answer no to all these? I'm not sure. So, But I was right on a couple of things, at least. The terrain is too dangerous. The south side of the bridge, you would encroach on two different people's property. But he threw in there it would take a substantial amount of time and resources to take the jury to those areas while ensuring they were sequestered. That's very good too, even though they could shut down the trail and that area. But the biggest one I think that is important is that the area does not look the same as it did at that time. Oh no, we would not want that. Nope, it's just me reading along. How not dangerous it is. Oh, it's dangerous. I've been there several times, walked down those hills, and it is not fun. All right. Let's see. The next one we are going to read is from 927. And it is the state's motion in limine regarding defense witness. So it says, comes now the state of Indiana by prosecutor Nicholas M. McClellan for the 74th Judicial Circuit and respectfully requests that the court enter an order prohibiting the testimony by Mr. William Tobin, a listed defense witness, regarding firearm examination in general or the firearm examination specifically in this case, until a hearing may be held outside the presence of the jury to determine the relevance of Mr. Tobin's testimony. In support of its motion, the state would show the court the following: that William A. Tobin is listed as a defense witness and was deposed by the state on September 20th, 2024. Mr. Tobin has testified that he is a forensic metallurgist and material scientist. He has a Bachelor of Science degree in metallurgy and a Master of Arts degree in special studies, which he testified was primarily the study of law. In his deposition, Mr. Tobin testified that when he was recognized as an expert in court, it has always been as a forensic metallurgist or material scientist. Deposition, page 6. Mr. Tobin stated that he has not examined the evidence in this case, though he testified he has reviewed some of the reports and notes of the state's firearms examiner. Ms. Melissa Oberg, Mr. Tobin, testified that though he has not reviewed all of Ms. Oberg's materials, he has what he typically needs to be able to opine on the methodology that's used. Deposition, page 20. Tobin went on to explain that the state's firearm expert witness conclusions are based on a flawed methodology. According to Mr. Tobin, the first flawed methodology is the AFTE, the Association of Firearms and Toolmark Examiners theory of identification, and this theory is what almost all firearm examiners follow, whether or not they are members of AFTE. Number 5, that Ms. Oberg, at the time of her examination, was a forensic examiner with the Indiana State Police, and she, along with other Indiana State Police firearm examiners, follow and apply the AFTE theory of identification. Mr. Tobin is not an expert in the field of firearm examination. unlike another listed defense witness, Dr. Eric Warren. Dr. Warren, like the state's expert witness, Ms. Oberg, is not only a member of AFTE, but holds or has held leadership positions within AFTE. Mr. Tobin's expected testimony will be that all firearm examiners, including Ms. Oberg and Dr. Warren, follow a flawed methodology and their opinions are not scientifically reliable. Wow. So the state talked to this guy and realized he was not an expert in what they needed. So they dismissed him, and the defense jumped on him, and now they want him as a witness. However, the state believes that Mr. Tobin, who is not an expert of the field of firearm examination, lacks the qualification to testify regarding the firearm examination in this case, and that his knowledge is not such that it would help the tier of fact to understand the evidence or to determine a fact in issue. In this case, further, the state believes that Mr. Tobin's testimony would lack relevance under Indiana R. 401. Since he is not an expert in the field of firearm examination, finally, that the probative value of Mr. Tobin's testimony would be substantially outweighed by a danger of confusing the issues and misleading the jury. The state believes that the question of whether or not Mr. Tobin should be permitted to testify in this case is very similar to a recent case out of Marion County, State of Indiana versus Caden Smith. In the Smith case, Judge Harrison ruled that Mr. Tobin would not be permitted to testify, and in her order dated January 29, 2024, said, the witness, Mr. Tobin, was being called by the defense to testify only as to the shortcomings of firearm examinations in general. The witness has not tested or reviewed any of the evidence in this case. The defendant will have the opportunity to cross-examine the state's witness to present his defense as the shortcomings of firearms examination. The court now grants the state's motion in limine, paragraph 5, to Mr. Tobin. Wherefore, the state of Indiana, by prosecuting attorney Nicholas C. McClellan, respectfully requests this court to grant the following relief. A, order the defendant, through his counsel and witnesses, to refrain from mentioning, commenting, or making any reference whatsoever, either directly or indirectly, to any of the above matters without first obtaining permission of the court outside the presence and hearing of the jury. B, to further order said person to make no reference to the fact that this motion has been filed and granted, and all other relief just and proper to the premises. I think that is an excellent request. If this guy is not, and I repeat, is not an expert, then he should not be testifying, because the defense team can obviously throw questions at the state's expert and try to debunk anything that they testified to when the state was questioning them. Okay, next one we're going to read is the non-party Yep. Okay. Just had to make sure I had the right one. Okay. This is also from September 27, 2024. Non-party Indiana Department of Corrections response to defendant's motion to compel deponent to answer certified questions. Now, we already saw this is a non-party. The Indiana Department of Corrections is putting this in there. You don't see this all the time, but it's in this one. And it says the Indiana Department of Correction, a non-party by counsel, responds to the defendant's motion to compel answers to certified questions and states procedural background. 1. On September 23rd, 2024, Richard Allen filed his motion to compel deponents, including John Gallipo and Correctional Sergeant Joshua Robinson, to answer certified questions. 2. Mr. Allen did not serve his motion on the Department of Corrections. The Department of Corrections objects to the motion with respect to the certified questions directed to John Gallipo contained in paragraphs 6B, 6C, and 6D of the motion because those questions call for information protected by attorney-client privilege. Number 4, the Department of Correction objects to the motion with request to the certified questions directed to Correctional Sergeant Robinson contained in paragraphs 7A, 7B, and 7C of the motion because those questions call for information protected by attorney-client privilege. Department of Correction personnel. 5. John Gallipo is the former warden of Westville Correctional Facility. Mr. Gallipo signed an affidavit in his then capacity as acting warden. That affidavit appears in the court record on October 10th, 2023, as an exhibit to the state's response to defendant's verified motion for immediate transfer of custody. Number 6, Mr. Gallipo was deposed by defense on March 22nd, 2024, and questioned about his affidavit. The Department of Correction was present by counsel at that deposition. 7. Joshua Robinson is a correctional sergeant at Westville Correctional Facility. Correctional Sergeant Robinson signed an affidavit in his capacity as correctional sergeant. That affidavit appears in the court record on October 10, 2023, as an exhibit to the state's response to defendant's verified motion for immediate transfer of custody. Correctional Sergeant Robinson was deposed by defense on April 18, 2024, and questioned about his affidavit. The Department of Corrections was present by counsel at the deposition. Okay, so that makes sense why they are against these questions. Because at the time that these gentlemen were deposed, they had attorneys present for the Department of Corrections. So their attorneys told them not to answer those questions. Elise Gallagher holds the title of Deputy General Counsel for the Indiana Department of Correction and is an attorney licensed to practice law in the state of Indiana. Deputy General Counsel Gallagher provides confidential legal advice to the Department of Corrections. Attorney-client privilege. In general, communications between an attorney and a client on a legal matter within the scope of the profession should be strictly confidential. And they cite cases here. Attorney-client privilege applies to all communications between the client and the attorney for the purpose of obtaining professional legal advice or aid regarding the client's right and liabilities. The person claiming attorney-client privilege must show that the consultation was a professional one and that an attorney-client relationship existed and confidential communication was involved. Deputy General Counsel Gallagher was consulted in her professional capacity and provided confidential legal consultation for her client, the Indiana Department of Correction, by communicating with Mr. Glippo concerning his affidavit, which pertains to his professional role with the Department of Corrections. She was consulted in her professional capacity and providing confidential legal consultations for her client, the Indiana Department of Correction, by communicating with Correctional Sergeant Robinson concerning his affidavit, which pertained to his personal role with the Department of Corrections. Once again, privileged communications are outside of scope of discovery. Application to Mr. Glippo. The answer to the question identified in paragraph 6B of Mr. Allen's motion is protected by attorney-client privilege. Question. And so what were you asked to do when you got the document? Basis of privilege. Mr. Glippo's testimony was that he believed the affidavit to have been prepared by the legal team at the Indiana Department of Correction, that he had an in-person meeting with someone on the legal team. The question calls for a response of what Mr. Glippo was instructed to do by a DOC attorney at that meeting. Got it. The answer to question identified in paragraph 6C of Mr. Allen's motion is protected by attorney privilege, client privilege. Question. Did they give you any reason why the defense could not go see where Richard Allen was living? Basis of privilege. Mr. Glippo's testimony was that the decision in question was made by the legal team at the Indiana Department of Correction. The question probes the legal justification provided by the legal department. Moreover, in order to compel an answer to the question identified in paragraph 6C of Mr. Allen's motion is unwarranted because, notwithstanding the objection, Mr. Glippo answered the question. The answer to the question identified in paragraph 6D of Mr. Allen's motion. Question. Do you know why they made that decision for a no-phone policy in Westville Correctional Facility? Basis of privilege. Mr. Glippo's testimony was that he believed the policy decision to have been made by the Department of Correctional legal team. This question calls for Mr. Glippo to divulge the legal team's rationale. The answer, application to Correctional Sergeant Robinson. Okay. So they're saying that these are also protected by attorney-client privilege. Questions. Generally describe to me what kind of questions these were. Questions for the affidavit prepared by Elise Gallagher. I'm not asking you about what Ms. Gallagher talked to you about. I'm asking you what questions you answered for the affidavit. Basis of privilege. Correctional Sergeant Robinson's testimony is that he spoke with Deputy General Counsel Gallagher about the affidavit. The question directly seeks communication between Deputy General Counsel Gallagher and Correctional Sergeant Robinson for the purpose of preparing the affidavit, namely what questions Deputy General Counsel Gallagher asked or provided to Correctional Sergeant Robinson to assist in preparation of the affidavit. Conclusion. For the reasons stated herein, the court should deny the motion to compel as the questions identified in paragraphs. Wow. So, the moral of that is we thought looking at the questions, they weren't too bad. Well, now we know that the questions are relating to conversations these gentlemen had with counsel. That is a no-no. All right. Next. So, Exhibit 1, this is 9/30/2024. Caution external email. Mr. Siegel, the exhibits that are not confidential or subject to non-disclosure will be available after the conclusion of the jury trial currently scheduled October 14th through November 15th, 2024. If there is a conviction, the availability would be delayed until after the sentencing hearing. Any inspection would occur in the Allen County Courthouse. Now, this is a request for an inspection. Bob Siegel says, Dear Judge Gull, under the Indiana Rule of Court rules on access to court records, I am requesting to inspect the exhibits submitted by the defense and state during 3 days of pretrial hearing, July 30th through August 1st, 2024, in state of Indiana versus Richard M. Allen. I am aware that some of the exhibits were submitted under seal at those hearings. While I did not see either party file a separate written notice identifying the specific Rule 5 grounds under which they are seeking those exhibits to be excluded from public access, as required by ACR Rule 7. I want to make clear that I am not seeking to inspect any exhibits that the defense or state entered into the record under seal. I am seeking to inspect only those exhibits that were submitted into the public record. In addition, I realize you and Ms. Williams have busy schedules and many other cases to which you are attending. While I would prefer to inspect and to receive the records electronically, I am happy to find a date to come to the Allen County Courthouse or other facility to inspect the records at a location that is convenient for you. You or Ms. Williams can contact me at phone number, email address to schedule time for me to inspect the exhibits. All right. Now we have exhibits A, B, C, and D. Exhibit A. Defendant's Exhibit A was marked for identification by Mr. Rossi. Let me hand you what's been marked. We marked as Defendant's A. Is that a document that you recognize? Yes. That an affidavit basically that's signed by you? Correct. Do you mind if I step over there just because I don't have a copy? Because I only made 2. So did somebody interview before? This was before you signed this? Answer, did somebody interview? Who prepared this affidavit? I believe it was legal. You mean like Department of Corrections legal? Correct. Could it have been Ms. Gallagher, maybe? Possibly. I've been talking to her a lot. Possibly. Mr. Ridland, I'm just going to ask that there not be any questions about conversations that Ms. Gallagher provided. Mr. Rossi, I might ask one. You can object, but I appreciate you pointing that out. By Mr. Rossi. So you didn't prepare this. You didn't type this up. No. Do you know who typed it? Do you know for sure? I don't know who typed it. I did have a conversation with legal about this. Did your conversation, was this like a 5-minute conversation? Was it a meeting? It wasn't a meeting. It was a conversation. Phone call, in person. And so how did this document get to you before you put your John Hancock on it? I think it was, I'm not sure if it was addressed through concerns after the patches were discovered. I don't know if someone asked for it. I don't know if your firm asked for it. I'm not sure exactly why it was prepared. You didn't ask to prepare it? No. I'm gathering that. Correct. Did you send an email to anybody with the bunch of bullet points that are similar to the numbers here? No. The question I asked earlier, forgive me if I didn't understand the answer. How did you get this document before you put your signature on it? Was it an email attachment? Was it handed to you? It was in person, I believe. And so what were you asked to do when you got the document? Mr. Ridland, I'm going to object to the extent that it involves a conversation with a DOC attorney. If your answer involves that, I'm going to instruct you not to answer. But if it's something other than that, then you can answer. By Mr. Rossi. I shouldn't have cut him off, but I did. I just asked you a question. You were going to tell me the conversation you had with the DOC lawyer, correct? Mr. Rossi, certify the question. So in that hearing, they specifically objected because this was a conversation with a DOC lawyer. But yet, the defense is trying to make these witnesses divulge attorney-client privileged information. This is not going to float. I can tell you that. All right, Exhibit B. Question, and then later on we asked again. I think we even took it to the judge, but we were always denied the opportunity. We, as Richard Allen's lawyers, were denied the opportunity to go see where he was living. Is that accurate? Answer, yes. Question, why would we not be allowed to even just go look and observe? Answer, that was not my call. Question, whose call was that? Answer, legal. Question, did they give you any reason why? Answer, no. Mr. Ridland, I'm going to ask you not to answer if the answer involves advice you got from a DOC attorney. Mr. Baldwin, certify that question. By Mr. Baldwin, do you know which people from legal gave you advice, which particular attorneys? Yes. Who are they? Mr. Ridland, you can answer that. The witness, Ms. Gallagher, I believe. So as these individuals, the warden and Correctional Officer Robinson, were being deposed, their attorney was sitting there right with them. They were the ones advising them what questions not to answer and what questions they could answer. All right, let's look at Exhibit C. Okay, so it starts out bringing our phones in, and you knew that we were bringing our phones in from the first time that we were there to see Richard, all the way up to and including April the 3rd, 2023. Answer: I knew that permission was granted for you and Brad to bring the phones in. It's typically no phones are allowed, so special permission was granted. Question, and I understand that. And my question is, you were aware that we were able to bring our phones in from December of 2022 all the way up until April the 3rd and including April the 3rd, 2023. Answer, I'm not sure of the time frames. I just remember that you were allowed to bring your phones in at one point, and then that decision was overruled, and then you weren't. I don't remember the time frames. Question, who overruled, Who overruled the decision that allowed us to bring our phones into Westville Correctional Facility? Answer, I think the decision was to revert back to what policy was and no phones. Question, who made that decision? Answer, I believe legal. Question, do you know why they made that decision? Mr. Ridlin, I'm going to object and ask you not to answer if it involves something that you were told by legal. Mr. Baldwin, certify that. Question, was the fact that a photograph was taken showing the condition of Richard Allen on April the 3rd, 2023, a reason to not bring the phones in? Answer, I'm not sure. Question, are contact visits no longer available for the general population? Answer, say that again. Question, I was recently within the last few months, I was at the women's prison on 10th Street. And while I was there visiting with this person, there were other family members at a table visiting their family, and there was close contact and vending machines and all that. Is that allowed at Westville? That type of contact in the general population, not those people where Richard Allen was staying. You're talking about in-person contact? Question, in-person contact, yes. Answer, yes. Okay, now let's look at the last one. Exhibit D. Okay, so this is a few pages. Answer, no. Question, and you were in contact with all of these people? Answer, to some capacity, yes. Question, but none of them ever said to you, like, why do you have an I hate people patch on your chest? Answer, no. Question, I'm going to mark this affidavit as Defendant's A. Okay? Defendant's Exhibit A was marked for identification. Take a look at that before I ask you questions. I want to make sure you get a chance to look at it so you know what it is. Let me know when you're done and I'll ask you questions about it. Ready when you are. Question, thank you. You're familiar with the affidavit? Answer, I am. Question, and this is an affidavit basically that you've signed, right? Answer, yes. Question, your signature is on the second page, is that correct? Answer, yes, sir. Question, I don't want to sit here and play reindeer games. There's a reference on here that I think it was September 19th of 2023 that you stopped wearing the patch. Is that correct? Answer, yes. Question, Paragraph 10. Answer, yep. Question, and there's also a rifle stamp date up in the corner, which you have nothing to do with, but it's October 10th. Answer, yes. Question, do you believe that you probably signed this between two dates, or was it some other date? Answer, it was between those two dates. Question, what role did you play in preparing this affidavit? Answer, I was sent the questions and I answered them. Question, are these the questions you were talking about earlier? Answer, yes. Question, that I was kind of confused by? Answer, yes. Question, who sent you the questions? Answer, I want to say it was the state's attorney that sent them to me. Question, in what form did you get the questions? Answer, email. Question, through what email? Answer, my state email. Question, what is your state email? jrobinson5@idoc.in.gov. Question, do you know which state attorney sent that to you? Answer, not off the top of my head, I can't remember. Question, if I gave you some names, do you think you would remember it or not? Answer, I could probably get you a narrowed down list of who it could have been. Question, there's three names and that I know of. One of them is McClelland. Last name, McClelland. Answer, no, I don't think it was. Question, Mr. Luttrell, down here. And he spells out Luttrell. Answer, no, I don't think it was him. And Ms. Diener? Answer, I don't think I've ever heard of either of the last two. I apologize. I've only heard of the first one, and it definitely wasn't him that sent it. Question, what about Mr. Mullen? I haven't heard that name before. So you got some questions and you answered them. Answer, yeah. Question, generally describe to me what kind of questions these were. Answer, they were questions. Mr. Ridlin, I'm going to ask a clarifying question. Could this have been from Miss Elise Gallagher? The witness, yeah. Mr. Ridlin, I'm going to instruct you not to answer what your email conversation was with Ms. Gallagher. Mr. Rossi, certify the question. I'm going to ask you I'm not asking you about what Ms. Gallagher talked to you about. I'm asking you what questions you answered. Mr. Ridlin, if it's questions that Ms. Gallagher sent you, I'm going to instruct you not to answer. Mr. Rossi, certify the question. Question, were they questions that she asked you to answer, or were they questions that she asked you? Mr. Ridlin, you can answer that, but only answer the question that he asked. Don't elaborate. And they are specific. The witness, allow me to clarify. You said, were they questions she asked me to answer, or were they questions she asked me? Question, my view of this is that she sent you a list of questions, like formatted questions, and you went through a questionnaire and answered. That's what my impression is. Is that incorrect? Answer, I guess. I don't think that's incorrect. No. Question, or let me just to distinguish this. Did she just type you a personal email and say, I've got 5 questions for you. Question number 1 is this. Question number 2 is this. Answer, no. Question, that's not what it was. Answer, no. Question, you weren't having a conversation with her. Answer, no. Question, you were answering a set of questions that she posed to you in some format. Mr. Ridlin, you can answer that much. The witness, yes. Then my question is, what were those questions? Mr. Ridlin, all right, I'm going to instruct you not to answer. Mr. Rossi, I'm going to ask to certify the question. This is lawyer stuff. We'll move on. Okay. The witness, yeah. Question, did you type any of those up? Answer, yes. Question, tell me which ones you typed up. Answer, all of them. Question, did you send these to her in some format? The witness, am I allowed to answer that question? Mr. Ridland, you can answer. The witness, yes. How did you do that? Via email. Did you create your own Word document? Answer, every time you open a Word document on a computer, it creates a Word document onto your computer. Question, so you did or didn't? Answer, I would say so, yeah. Question, I don't know. There's lots of other ways to prepare documents. Word perfect? My point is, did you actually start from afresh, or were you given a form that you tweaked? Answer, I was provided with a list of questions and I answered the questions. Question, do you agree with me? This affidavit in front of us does not have the asked questions. It has the responses to my questions. Question, all right. So you didn't type this. So you didn't type this up. Somebody else typed your responses and created this affidavit. No, this was my typing. The questions were not attached to what I typed. So the answers in its other capacity was on an entirely different piece of paper. Now we have two sets of documents. This was my piece of paper that I typed. So you went through and typed up answers 1 through 28. Yes. And you sent a Word document that looks something like this, right? No, it looked like this, minus the Carroll County stamp at the top. Did you put the legal language on the top? The affidavit part? Question, yeah. Answer, yeah, I think so. Where it says Sergeant Josh Robinson, Correctional Officer Westville, which is part of the Indiana Department of Corrections, affirms and swears to the following. Is that your typing? Pretty sure, yeah. And then at the bottom second page, let me draw your attention to the second page. Did you type, I swear under penalties of perjury as specified by 3544-2-1 that the foregoing representations are true and accurate to the best of my knowledge? As far as I remember. Where did you get all that language from? Okay, so this paper, before I signed it and sent it back with the answers attached to it, it looked exactly like this, except for the numbered boxes, 1 through 28, had questions attached. I answered the questions, signed the paper, faxed it back to the person who sent it to me. I'm trying to understand this because I don't have the document in front of me. I understand. I'm not trying to not overstep what I'm allowed to say. I hope you understand that. Question. He'll jump in. Trust me. Mr. Ridland, unless I object, you can answer the question. Question. So 1 through 28, those provisions, I'm going to ask this again just to make sure. Answer. Okay. Did you type those exact words up? Answer. I typed the words starting from number 1 to number 28 in response to the questions that were here. Yes. And then you would have sent that back to somebody? Yes. Paragraphs 1 through 28? Yes. And then the rest of the information on the top and the bottom that I just referred to was added to it? It could have been, yes. Oh, 1 second. It was on the paper already. The only thing different from the paper I'm looking at and the paper that got forwarded out was the paper that I forwarded out had the questions with my responses. Question, I see. Did you talk to Officer Jones before you prepared any of these? Answer, no. Did you guys ever have any conversations between the two of you about your affidavit and his affidavit before you signed them? No. What about after? No. Give me 1 second, please. Okay. Do you know who it was that you communicated with as you're sitting here today regarding that affidavit? Yes. Who was it? The witness. Am I allowed to answer that? Mr. Ridlin, you can answer it. The witness. It was Elise Gallagher. Have you talked with anybody from law enforcement since Rick Allen has been housed at Westville? What do you mean by law enforcement? Investigators, prosecutors, police officers? No police officers, no investigators. Elise Gallagher is not law enforcement. She's DOC. Okay, then no, I haven't. You've talked to no one from the Carroll County Prosecutor's Office? No, I don't think so. You've talked to none of the police officers involved in the investigation of this case? No. And no investigators? I know that's kind of a technical distinction. No. Let's go back to these patches. And that's where it ends. Wow. All right. We have one more last document to share. We're doing pretty good getting through these. News Media Coalition's motion to inspect public trial exhibits. The News Media Coalition respectfully moves the court to allow inspection of the state and defendant's exhibits submitted into the public record during the pretrial hearing in this matter conducted on July 30th, 2024 and August 1st, 2024. The News Media Coalition also respectfully requests that the court allow inspection of the state and defendant's exhibits submitted into public record during the trial scheduled to begin on October 14, 2024, and for other hearings that may occur in this matter. In support, the News Media Coalition states the following. A. Factual background. On August 26, 2024, WTHR, a member of the News Media Coalition, requested via email that the court allow inspection of the exhibits submitted by the parties during the pretrial hearings of July 30th and August 1st, 2024. The request pursuant to Indiana's access to court records rules. The other members of the News Media Coalition support the request. The request acknowledges that some of the exhibits were submitted under seal without any required written notice under ACR Rule 5 and classified that only the exhibits already submitted into the public record were part of the request. So this is basically what we already read. So I'm not going to go ahead and read that because we've heard that all already. So what is everyone saying? Let's see here. Okay, everybody's talking. I find it funny how some people were so quick to question the state because they were afraid RA would get off like Casey Anthony. So the state hired a trial consultant so that doesn't happen, with confusing the jury with matters that are purely just that confusing. All right, my cousin's friend got an okay. The state is directly stating keep anything out that is just used to create reasonable doubt, confuse, and mislead. All right. So basically, you're all having conversation with each other. I'm not seeing any questions. Yes, you are right. Everyone has the right to their own opinions. If you disagree, do it respectfully. All right. Marv, you think a plea could still happen? I don't think so. Yeah, we're too late for a plea. Reminder, the prayer walk for Abby and Libby is October 13th at 1:30 p.m. at the Monon High Bridge. The 1600 Old Camden Road, Delphi, Indiana, will, if you map that, it'll get you to the parking lot. I don't think it's going to last as long as what they originally said, because the defense is not going to be presenting the third party defense. So I'm thinking, let's see, she gave him 4 weeks. It might last the 4 weeks, 2 weeks for the prosecution, 2 weeks for the defense, maybe. They haven't said anything about the DP. Marv, are you in Delphi? Nope, not yet. I see pop out. Aw. That was a good comment, Dean. So, we are not that far away from trial starting. Tomorrow, I go by my daughter, and next week, by this time, I'll be in Delphi. No, I don't live there. I'm in Wisconsin. Yeah. So the plan is I won't be on tomorrow night. Saturday night is the 22nd anniversary of Tabitha Shuck Rains being found murdered. We are doing a vigil that night. Those that can make it down to the Tipton City Park, please do so. For those of you that can't make it, I'm going to do a live stream here, and we're going to try to connect with Mark and some others at the vigil. That'll be Saturday night. And yes, I am a cheesehead. Oh, I hope so. I can't believe it's finally happening. Never felt like it really would. Yeah, I agree. Oh, I'd have to look back at the record to see. But yeah, the last time it was just before the trial was supposed to start in March. I do a little bit. I have not watched the documentaries yet on that. I need to. But I know about the case and what it's about. There are in Northern, not very many, but a couple. Well, if the defense argument is so implausible and the case so strong against RA, why should they worry about it misleading the jury? They've been fighting tooth and nail to keep everything out. Why? It's very easy to let things into a case and have it not have anything to do with the person that's on trial. When that happens, it can become confusing to the jury. The motion of limines are standard through every single trial. Normally, the prosecution will have a motion of limine requesting that things are not talked about, and then the defense will also have one. In this case, the defense hasn't, but the prosecution absolutely did. You'd be surprised at what kind of things are in a motion of limine. I live in Northwood, seen elk, but no moose. Let's see here. And this is the biggest thing. If the defense had evidence that third party perpetrators were involved in this, the judge would have allowed it. But because they have no evidence that those individuals were at the crime scene or anywhere in the location of the crime scene, that is why she's not allowing it. I'm not sure what the prosecution has, but I know it's a lot more than what we think. And I guess in about 15 days, we're going to find out. I believe Libby's phone turned on from an alarm setting. We're going to find out more about that too. I'm sure that when that testimony comes through, whoever testifies about that phone, it's going to be more in detail than it was at the hearings. Hi, Miranda. We're just wrapping up here, Miranda, but thanks for joining us. All right. I don't see any other questions, so I'm going to bid you a good night. Thanks for being here. Click the like, subscribe, join the membership. I'm going to be doing some conversations about the P. Diddy case and Hollywood, and because of the sensitive information in these cases, that is going to be on members only live, because there's no way I can fully describe what's going on a regular live stream and keep my channel. and new merch is coming very, very soon. So keep your eye out. No, there was no evidence, even for Ron Logan. It's going to be the P. Diddy case that I'm going to talk about on members only, because 120 new lawsuits are going in place with him. So it's going to be wild. All right, everybody, I will see you Saturday night. Have a good night and a good weekend, and I'll see you soon. Bye. Thank you for watching Beyond the Evidence. Today, I gave you my own opinions and analysis, but I always encourage you to do your own research and form your own conclusions. If you're interested in true crime and want to join me on this journey of discovery, make sure to subscribe and hit the bell icon so you don't miss any of my uploads. If you'd like to support the channel, join our membership, and if you have any suggestions for cases that you want me to cover, feel free to leave them in the comments below. Thank you for watching, and remember, justice matters. This is Beyond the Evidence, and I'll see you in the next video.